Welcome to SentencingStats.com. It's October 30th, 2017, and I am Mark Allenbaugh. Today we are going to take a look at an interesting new case. This is the indictment of Paul Manafort and Richard Gates that was unsealed earlier today. They have been arraigned and both have pled guilty. Or not guilty, excuse me. And what today's presentation is looking at is what we here at Sentencing Stats think that their likely sentence may be, roughly. So the first thing we need to do is take a look at, their statutory maximum penalty. Some reports in the press are 80 years. Maybe my math is incorrect here. But at least for Manafort, it looks like it will be 65 years. Yes, counts 7 through 9 are missing because those counts only pertained to Gates and not Mr. Manafort. And today's presentation is just focusing on him. So you can see here, as I quick read through this, the indictment, these are the statutes of conviction, the count numbers, and the statutory maximum penalty that Mr. Manafort will be facing per count. And what one does is you add up all of the counts, the statutory maxima for all of the counts to get the overall maximum. So in theory, he is looking at up to 65 years in prison. He's not going to get anywhere close to that, but as you'll see, he's still looking at some significant time under the guidelines. For the guidelines gurus, here's my calculation, the way I calculate based upon the facts that are set forth in the indictment. And of course, those facts can change as a plea agreement is worked out, and some facts may be removed and others may be stipulated to, and there are various ways that a well-crafted and well-argued plea agreement can really reduce his exposure here. But at the very least, based upon what's in the indictment, here's what I calculate his guideline range, his final offense level to be, which is 39. Probably a couple of the ones in here may not apply ultimately, or would apply in a reduced fashion. Certainly the $18 million in fraud, that may eventually be negotiated down, although it's doubtful. Generally, when there's an amount alleged in the indictment, that tends to stay in there. The national security enhancement, this enhancement is very rarely given. There are just not a lot of national security cases generally. But if this national security enhancement applies, then he's looking at a +6 here. The other one, the other enhancement that likely will apply is some leadership role or role in the offense enhancement, and generally those can be a +4, +3, or +2. I'm giving him a +4 here because of the extensive nature of the offense conduct and the conspiracy. But that may end up being negotiated down or away once it comes time to plead guilty. But if the sentencing were held today and the facts that are set forth in the indictment are proven by a preponderance of the evidence, that's the evidentiary standard at sentencing, then I really think he would be, I think most probation officers would assign him a +4 leadership role. Then if he does plead guilty, over 97% of defendants do plead guilty once they're indicted. His acceptance of response, he would get 3 levels off for acceptance of responsibility. That brings him to a final offense level of 39. I'm assuming he's in criminal history 1. It's a safe assumption. That means he has little to no relevant criminal history, probably none. He's looking under the guidelines at 262 to 327 months, which is 21.8 to 27.3 years. But since 2005, by the way, here's the sentencing table. You can see down here, this is where I derived that sentencing range from. But since 2005, the guidelines have been deemed to be merely advisory, according to the U.S. Supreme Court. So judges no longer have to follow these particular sentencing ranges. Before 2005, they were mandatory. And chances were really high that he would be looking at at least a 262-month sentence. But now, since the Booker case, he is not. So, because the guidelines are now merely advisory, that makes statistics all that more important to see what somebody really is getting, and you'll see why, because it looks like he's not looking anywhere close to a 262-month sentence. So we could see what I've done here is using U.S. Sentencing Commission statistics data from 2006 through 2016, which covers over 850,000 defendants that have been sentenced during that period of time. And this, by the way, again, is all post-Booker. So we're just looking at data from the era when the guidelines have been advisory. There have been exactly 91 defendants that were exactly like Mr. Manafort, at least the way I calculate his likely guideline range to be. And that is he's in an offense level 39, criminal history 1, sentenced under 2S1.1. There are many counts of conviction, as we saw up here, but for technical reasons, I think it's going to be this 1956 charge, which is money laundering. That's really what's going to drive the sentence here, and that ultimately is the guideline that I think he'll be sentenced under is 2S1.1. So coming back to here, again, offense level 39, criminal history 1, sentenced under 2S1.1, and pleaded guilty. So that's taken all those factors into consideration. There were exactly 91 people that were similarly situated, or what I would say were identically situated to Mr. Manafort in terms of relevant guideline variables. So looking at all those individuals, the average sentence for that group of individuals was 166 months. So, almost 100 months off the bottom of the guideline range. So still a very significant sentence, 166 months, but, quite a bit less than the guideline range for whatever that may be worth to a defendant at this stage. I just picked an arbitrary low sentence here just to get a feel for what he may be looking at, how difficult it may be statistically. I shouldn't say difficult, but how statistically unlikely a low sentence might be. And in this case, I just chose 24 months to take a look at it, 2-year sentence. Only 1.9% of these 91 cases, so maybe like 2 or 3, received a sentence of 24 months or below. So it's very, very unlikely that he is going to get such a low sentence. I think he's 69 years of age. So frankly, even just a few years in prison may end up being a de facto life sentence anyway. But, that's something that his attorney is going to argue to the court to hopefully get what's called a downward variance. And as I've said repeatedly, since 2006, the guidelines have been merely advisory. So what judges can do is, it's a term of art, is vary below the guideline range. And so what's important is how often do they do it, and when they do it, how far below the guidelines are they going? Well, for how often, by the way, this is the median sentence, 180 months, which means half of the defendants received a sentence greater than 15 years, 180 months is 15 years, and the other half received below that. So, actually, I jumped ahead of myself with respect to variances. Looking here at the average sentences for those that are identically situated to Mr. Manafort, what I would consider identically situated, we can see that's actually even better, at least as of 2016, than what the overall average reported. The overall average, 2006 through 2016, reported the average at 166 months. But we can see last year the average was only 150 months. Now, we're talking only 91 defendants over an 11-year span, so about 8 defendants a year on average. So that's why you see such a significant fluctuation, because there's not that many by year. But nonetheless, you can see that while it's greater than it was in 2006, the average sentence now last year was 150 months. That's something that a defense counsel may want to present to a court to say, look at where sentencing really is in the post-Booker era for those identically situated to my client, in this case, Mr. Manafort. So Now, so we see what the trend for average sentences have been. Here is the rate of judge-initiated downward variances. What this means in English is that if there's 91 cases, 23% of the time, so maybe about 20 of the cases, just doing the math in my head, received a sentence below that really high sentencing range as a result of the judge exercising his or her discretion to vary below the guideline range. So the point simply is it's not unusual. And had I run this to see how often judges sentence below that range for cooperation with the government, that probably would yield a pretty big, a large chunk of those 91 sentences also getting what's called a 5K 1.1 for cooperation. At any rate, almost a quarter of the time, judges are going below the guideline range. So that's good for Mr. Manafort. You could say, look, Your Honor, not everybody's following these guidelines. At least not everybody is where there are cases identical to mine. 23% of the time, they're going below the range. So judges are going to want to know, well, how far below the range are they going? Pretty big, Judge. 74 months below the guideline range. We indicated as a negative number here to indicate that's below the bottom of the range. So in 23% of the 91 cases, judges decided to go below the guidelines. And when they did go below the guidelines, they went below 74 months below the bottom of the range on average. Sometimes more, sometimes less, but on average, 74 months below the guideline range. So, Mr. Manafort, nonetheless, because of his age, is still looking at, well, regardless of his age, he's still looking at a very significant sentence here. And even a sentence of just a few years may end up being a de facto life sentence for him, and that's probably his best argument at this point, is to argue for a really significant downward variance because of his advanced age. Recent studies have shown that that defendants that are sentenced to prison, it reduces, for every year they spend in prison, it reduces their life expectancy by 2 years. So if Manafort is, let's say he's 70 by the time sentencing rolls around, and he might only have, let's say, at best 10 years of life expectancy left. So a 5-year sentence is going to eat up all of his life expectancy. If he only has 10 years left, 5 years times 2, that's 10. There goes his life expectancy. He's definitely spending the rest of his life in prison. So, maybe like around 2.5 years of incarceration, that at least may give him some hope of actually seeing the light of day and living out, and not dying in prison, at least dying on the outside. So it doesn't look good for him. Unfortunately, overall, this will come up to creative lawyering. Also, some good arguments. So his guidelines aren't so high. Here again, where I think where hopefully I'm wrong, at least hopefully for his sake, is this national security enhancement won't apply, and no leadership role, at least no more than a +2. And there may be arguments here that the amount of money laundered, overstates the seriousness of the offense. So he may be able to get his guidelines down. But even if he gets them down to 9 levels, it's still a very significant sentence. So it'll be very interesting to see how this case pans out and what new developments are there. If Mr. Manafort, like Mr. Papadopoulos, as we learned today, there was another defendant in this case, in the special counsel investigation, that has already pleaded guilty and is cooperating with the government. That individual may end up doing no prison time, because depending on the amount of cooperation he is providing. Mr. Manafort, and we'll discuss this next weekend, do another edition where we can go through what Mr. Manafort might expect if he was to do a 5K, which is cooperation with the government, and see what defendants like him and others may expect for such cooperation. Thank you very much.